SJC-11908, Joshua Charbonneau v. the Presiding Justice of the Holyoke District Court.
Good morning, Mr. Rudolph.
Good morning, Your Honor. May it please the court. Paul Rudolph on behalf of the petitioner, Joshua Charbonneau, and with me is my co-counsel, attorney Ryan Schiff. There is no silence, there is no ambiguity, there is no conditionality in the language, the relevant language of Chapter 278, Section 18.
So can a defendant offer this plea at 6 p.m. in the evening when the court's not open? I mean, aren't there reasonable time restrictions that can be placed on the right to offer a defense cap plea?
Yes, that wouldn't be a reasonable restriction because court's not open, and so it would be impossible for a defendant to tender a plea, and that is the triggering language of the statute. The statute says if a plea is tendered, that's the triggering language. In the municipal courts, the district courts, or the juvenile courts, the court shall inform the defendant that it will not impose a disposition that exceeds the terms of the dispositional request by the defendant without giving the defendant the right to withdraw the plea.
Now, this is purely statutory, not constitutional, isn't it? Because the Superior Court has a different rule.
It's both statutory and rule-based because this is also a clear mandate.
Statutory and
Rule 12.
rule-based, but not constitutional.
That's correct. There is no constitutional right to plead guilty at all.
Don't you sort of argue a constitutional point, though?
The constitutional argument has to do with whether this rule has a coercive effect on defendants in trying to coerce them, or has the underlying purpose or effect of coercing defendants to plead guilty rather than proceed to their trial dates. But I don't think the court needs to reach the constitutional question at all because, as this court has said many times, this mandatory language is plain on its face. It provides no discretion to the courts.
Well, let me ask you this, though. You would agree, or maybe you wouldn't, but that take it out of this context. A particular district court or probate and family court says, we hear a 209A restraining orders absent an absolute emergency. We hear them. The session is from 12 to 3 or 1 to 3 and 11 to 12. I mean, they set times when that's what's going to happen in the court. And if you get there early, you're going to wait until 10 o'clock happens or something like that. So it's a I think the court would say, a reasonable regulation of time for purposes of running the court. If this, instead of saying, you know, you can do this up until 2 o'clock, and after that it's a Commonwealth capped plea. You just said, we're going to, yes, whenever somebody tenders a plea, what the statute says is true, but you may tender a plea only, you know, up to this amount of time before the trial. You couldn't do that? If it was a reasonable period of time?
I think that's actually a very different question, which is whether the court can refuse, can exercise its discretion in refusing to accept a plea after a different date. That's a different question than allowing a defendant to tender a plea but treating it as prosecution capped, because the latter, which is what we
Aren't you better off with what this than what I've proposed?
Well, honestly, I don't think this is about what we're better off with or not. This is about applying the statute and applying the rule. I think to get to your question, here's what I think the court could do and couldn't do in that situation. I think the court has discretion to refuse to entertain a plea if there is a legitimate sort of case-specific reason to do so.
Can I just interrupt you there and ask you if this scenario, what if the rule were in place as it is currently in Holyoke District Court, but there was added to that that the judge nonetheless could exercise discretion to entertain a defense cap plea on the day of trial in certain circumstances, as I gather are some of the concerns that defense counsel in these circumstances might have, that notwithstanding the conference a week or 2 weeks earlier, no, that witness actually is a no-show and is never going to show. That kind of concern about gauging the propriety or the desire or the the full case strength day of. Is that okay?
It's not. And as this court said, and we cited this at our brief on page 8 in Davila versus McGonigal, the carving out of any exception to a clear statutory mandate is for the legislature. It's not for the judiciary. There may be good reasons to do it, just like Judge Ball had very good reasons in Commonwealth versus Guzman to decide in her discretion that Mr. Guzman did not need to be subject to GPS monitoring. But this court said the legislature issued the plain language of that statute, which said that a defendant who is on probation for certain sex offenses shall wear GPS.
But isn't that different than setting reasonable time, place, and manner regulations?
Again, it is different in that sense, but what's not different is that the legislature here created this statute, and they did so without any exceptions, and they used the type of language that this court has always said is mandatory and gives judges no discretion. Now, getting back to, I think, both Justice Duffley and Justice Botsford's earlier questions about what's better or not for our clients, I would also say that if a regional administrative justice of the Hamden Superior Court, for example, said, I think it would reduce the number of
Not
jury...
the Superior Court, because they don't have this right, so, right?
Well, and this is my point, which is if that justice said, I think it would actually reduce the number of jury trials if we gave defendants defendant-capped pleas for, let's say, the first 3 months of their cases, because I think that would resolve a lot of cases that might otherwise go to a jury trial. The Commonwealth would rightly challenge that policy under 211.3 because it would be in violation of the clear language of the rule this court adopted in Rule 12, which says that pleas in the Superior Court are prosecution capped. Again, this is the clear language not only of the legislature, but of the rule that this court has adopted.
Could the judge here have announced that she would not be bound by the defendant-capped plea? By the defendant's request? Just announce in advance.
Well, that's effectively what this standing order does.
But under the rule, you could do that, can't you? Can't the judge do that? Can't the judge say, I will exceed the recommendation of the defendant, and then give the defendant a chance to withdraw his plea?
Sure.
So a judge in advance could say, it would be my intention to exceed the recommendation of the defendant in advance.
Yes.
And put him in, essentially, as a practical matter, in exactly the same situation he's in now.
But I think that would be, that would still be giving the defendant the right to withdraw his plea.
Okay, and if the defendant doesn't withdraw his plea, if the defendant decides that the judge, he will go with the judge's announcement that in this case she would exceed the recommendation of the defendant. If he pleads, that's the end of the case. If he decides to withdraw his plea, then the case proceeds to trial right then and there, doesn't it?
That's correct.
But you're saying that this does not preserve the right of the defendant to withdraw the plea.
That's right. Here, in this case, under this amended standing order, the defendant would be stuck with the sentence that the judge wanted to impose, wouldn't have the ability to withdraw the plea. And that's contrary to what the legislature mandated.
So I'm still...
Even under Justice Spina's, I would assume you would consider it to be problematic for a judge to declare in advance that without looking at what the defense is offering, the judge is going to declare in advance that he or she will exceed it just because it's offered late.
Oh, yeah, I'm sorry. I understood Justice Spina to suggest what does sometimes happen, which is judges, before they take the plea, they actually hear kind of the dispositional
Oh, based on the
requests.
evidence. Okay, but I think
Yeah.
he was suggesting that as a rule, as a rule of court, the
Oh,
court
yes.
will not accept it, no matter what it may say.
If that was the question, I misunderstood it, and I do agree with you, Chief Justice
So
Gantz.
what can a court, I mean, it is obviously, well, I can say obviously, it appears to be a problem to not know how many cases are going to go to trial with regard to a particular day, and if a case is going to plead, obviously it's best for that case to plead early so that the court can schedule trials and have fair and firm trial dates. If the court can't do this, what can the court do to accomplish that?
Well, we fully appreciate the goals that the court is trying to accomplish here. And we embrace all of the other features of these trial readiness initiatives as being both lawful and seemingly effective in accomplishing these goals of achieving court efficiencies and improving juror utilizations. And I think it's significant that both in 2009 and 2014, the jury commissioner and the jury management advisory committee issued best practice memos on jury utilization. And those memos outlined a whole range of approaches and methodologies that the courts can adopt to improve jury utilization. The Commonwealth has seen a huge improvement as a result of this court and the trial court's efforts.
Some improvement.
Very significant improvement. I think the court in the 2014 memo referred to it as tremendous improvement. And the court can adopt pretty much all of those best practices. I think most of them have been adopted, although perhaps not all. And what is, I think, telling is that even in the 2014 memo, which postdates what was occurring at least in the Greenfield District Court, where this practice had been adopted of converting defense cap pleas to prosecution cap pleas on the day of trial. I'm sure the court, the committee was aware of that. It's not among the recommended best practices.
But let me ask you this, there is another cost, though, which I think the Commonwealth raises. So one question is, I mean, the cost of calling a whole bunch of police witnesses when it's going to plead, that mounts up over time, highly. So that's one. But my other question is, I still don't know whether you think here, Judge Walsh could have had an order saying, we will accept, you can plead guilty, but you have to, if you're going to plead guilty and not go to trial, you need to do it by 2 o'clock the afternoon before the trial is scheduled to start.
Yeah, so I think the Iowa Supreme Court in a case called State versus Hager, which is cited at footnote 4, page 14 of our brief, addressed this issue of plea cutoff dates, which I think is really what you're asking about, Justice Botsford. And I would agree with what the Iowa Supreme Court said in that case, which is that judges do have discretion to refuse to exercise, to entertain a plea. But a blanket policy of not accepting a plea after a certain date is the, quote, very antithesis of discretionary decision-making.
But we have a Rule 2 of the Rules of Criminal Procedure says that these rules are intended to provide for just determination of every criminal proceeding. They shall be construed to secure simplicity in procedure, fairness in administration, and the elimination of expense and delay. What's so unreasonable about placing a limitation on a defendant's ability to do a defendant's capped plea when he has months to do it?
Well, a couple of things. First of all, this isn't just a violation of Rule 12 in our view. It's also a violation of the statute. So, although Rule 2 may speak to how to interpret Rule 12, it doesn't really speak to how we interpret Section 18. But having said that, I think you're asking about why is this such a big deal? And it's a big deal both legally and practically. Legally, because as I've said many times, it violates the plain language of the legislature's mandate to the courts. But practically speaking, I think the amicus brief of the ACLU and MACDIL really does discuss and properly articulate why there are many practical reasons why defendants are not in a position, and their lawyers are not always in a position to know whether or not they should plead guilty or not prior to the trial date. What the judges in Holyoke and Greenfield are doing, I think, in terms of the trial readiness conferences, is really effective in getting the parties in a position where they might be more capable of making that decision, where the prosecutors are forced to really look at their cases and communicate with their witnesses. But we know that that doesn't happen a lot, and it's not through no fault of prosecutors. In the way it works in district court, you know, prosecutors aren't necessarily even assigned individual cases. They often don't even talk to their witnesses until the morning of trial. The defense lawyers don't know what witnesses are telling the prosecutors. They don't know whether their witnesses are going to show up, that type of thing.
Wouldn't the report process that's supposed to take place before speak to all of those issues?
In theory.
So you would know whether or not the prosecutor's been able to talk with the witnesses?
In theory, but all they're really asked, my understanding is, have you had contact with your witnesses? The witnesses are not required to be there on the trial readiness dates, so they're not always able to resolve Fifth Amendment assertions unless they happen to show up. The prosecutors may have had contact with them, but haven't actually sat down and spoken to them to hear what they actually have to say about the case, other than reviewing what's in the police report. So it is an effective method of moving us further down the road to being able to resolve cases earlier, but it's certainly far from perfect, and there are many practical reasons why.
Once someone has selected the jury trial route, I mean, this isn't like day-to-day business. This is, you've selected a jury trial route, a firm date has been set for your jury trial. You mean the lawyers still don't do anything until the morning of trial? The jury trial, it's just not something that happens like in 10 minutes in the morning session.
I'm not saying the lawyers don't do anything, but I do know certainly the way it works with many prosecutors' offices in the district court is the cases are not assigned to individual prosecutors, and sometimes not even until the night before the trial. They know you're assigned to the jury trial session.
So who shows up at the hearing, at the pre-trial? The one that's supposed to get this into shape?
You know, a prosecutor is assigned to that session and reports whatever information has been gathered by the office.
It seems like you're asking us to accommodate the principle of non-preparation.
No. I'm asking you to, number one, respect the legislature's mandate to the courts, and number two, to recognize that there are practical realities in the court, and with not only, this is not just on the Commonwealth, and it's not necessarily their fault, but on our clients who may not be able to get off from work in between the time of the trial readiness conference and the trial date to come in and offer a defense cap plea. There are lots of practical limitations.
I have one question, and I realize your time is well over, but if you know the answer to this, I couldn't find it. Are we unusual in this respect? Just the legislative mandate, as you call it?
In terms of having defense cap pleas? Yeah. That's a great question, and I don't know the answer to that. I do know that before de novo turned over to the one trial system, it wasn't prosecution or defense capped. I see that I'm out of time. I'll rest on my briefs. Thank you.
Good morning, Your Honor. Suzanne Reardon, Assistant Attorney General on behalf of the respondent in this case. The provision which is at issue in this case is part of a larger trial readiness initiative which certain district courts have implemented with the goal of streamlining district court jury trial sessions, which have been known to be very chaotic and not as efficient as they could be.
Ms. Reardon, do you know whether, since the Holyoke order was stayed in whenever, June, I think?
Yes.
Is there any data in terms of the effect, because it's, as you just said, it's part of a larger trial readiness initiative. Is there any information available as to whether there's been any slippage in the sort of efficiency rate of resolving cases in terms of their trial date?
Not that I know of. I know that some of the reports that are included in the appendix deal with, I believe the jury commissioners deals with the period between May and June. Now, May arguably is before this was implemented in Holyoke, but it does not seem from those reports that there has been any significant difference.
Yeah, and I was really thinking about since since it has been implemented and then it was stayed, whether there's been any,
I
you don't
can't
know.
speak to that.
What happens if, under the scenario that we have before us, with the elimination of the defendant cap plea on the day of trial, and the prosecution says, okay, Judge, I need a continuance, I'm not ready to go to trial. And the defendant says, well, I got my witnesses here, I'm ready to go, and they're not going to be here, 3 weeks from now when the prosecution wants to do this. I would like to plead guilty. Can't do it and get a defendant cap plea under this regime?
Oh, on the day of trial, you mean?
Yeah.
I would say no.
Well, is that fair?
I mean, at that point, I would say if the Commonwealth is in a position where their witnesses aren't ready and they aren't ready to go to trial, they're in a much less strong position in terms of putting forth a higher sentence if there's going to be a disparate plea. I think that's a different scenario.
Well, I
because
suppose the
Commonwealth
judge can
can't
do
go
a couple
forward.
of different things. The judge can dismiss the case
Exactly.
or continue the case, and therefore, this 2 p.m. before the trial date is no longer effective, and, I mean, you're in the zone where you can offer a defense cap plea.
Yes,
So there's a practical solution to that problem.
yeah.
Or the judge could exercise discretion, do you think, at that point, and say, well, actually, rule doesn't apply in these circumstances?
Probably,
Under Rule 2.
I mean, arguably, yes. I think in that scenario, a defendant would probably be less likely to offer a plea if he thinks the Commonwealth can't prove its case. I don't really know that he would be offering a plea at that point. He would probably be more likely to move to dismiss the case.
Now, I know this is not your order, and the AG is being a good soldier and representing them. This is not an AG decision. But how far does this principle extend, that which makes a court more efficient permits a presiding justice to alter requirements of a statute? I mean, for instance, I would think it would be a problem if a judge said, it's really a problem for all these domestic violence victims to come in after 2 o'clock. So I'm going to establish a rule that if you come in after 2 o'clock on a court day, you've got to prove your case by clear and convincing evidence and not by a preponderance, because that will encourage them to come in earlier. I would assume you would have a problem with that.
I would have a problem if he's changing the standard.
But why is this different?
I think this is different because it can be considered more of a scheduling issue. I mean, I would point out that the other district courts that have implemented this earlier, like Greenfield District Court, they actually require the defendant or limit the defendant cap plea to the trial readiness conference, which is a week prior to trial. And since that's been in place since 2013, there has not been a challenge to that.
Well, that doesn't mean it's okay.
No, that doesn't mean it's okay, but my point is that this is a much more reasonable limitation, especially in light of this trial readiness initiative, where the point is to get things more in place. You have this conference a week or 2 prior to trial. Everyone should know where they stand. At that point, there's discussion about a plea. It's much more reasonable to expect that a defendant will know whether he wants to plead guilty.
But we still have the shall in the statute, and does not provide for exceptions. So how does a presiding justice, albeit for perfectly sensible reasons, get beyond the shall? And what principle does that establish, that mandates of the legislature can be avoided by a presiding justice where the needs of the court so require or so suggest?
Your Honor, yes, we are faced with the word shall, and clearly that can be interpreted more than one way. If this court decides that shall means shall, then that's
How
true.
many other ways can it be interpreted?
Well, as in my brief, I cite to other situations in which there are absolute defendant rights, such as the right to present a defense, where there have been limitations put on, such as if a defendant wants to present an alibi defense, he has to give notice prior to trial. Similar type limitations, I know they're not exactly the same, but I think there have been instances where a court can place reasonable limitations, and I think in this case it's really just a time limitation.
But what do you do about the statute? I mean, as far as notification about alibi defense, insanity defense, that's in a court rule. Here we're dealing with a statute. How do you make that go away?
Well, there's another case, again, not exactly on point, that I cited to, in which there was a statute in which defendants are granted certain rights after arrest, including the ability to make a telephone call. In the case Maylott in my brief, again, it's not exactly the same. And in that statute, actually, it provides that it has to be given within an hour of being arrested or booked. And this was long after that. And the defendant moved to dismiss in that case, and the court said that's not the proper remedy. Now, I know now that's not exactly the same, but there are other situations where there was some leeway.
What's your position? And Mr. Schiff said, you know, follow what, I think it was Ohio, but what's your position? Iowa. What's your position about whether, rather than say, we'll take a Commonwealth capped plea on the day of trial, the court just said, we're just not accepting any pleas after X time? Is that okay?
I actually think that would be okay, because the defendant does not have a right to plead guilty at any time. He does not have a right to change his plea at any time during the trial process. So I think that actually would be okay. I think where the problem we run into is that there is this specific provision in the statute that says if you're going to plead guilty, you shall give the defendant
Well, that's
this
right, but this would answer that.
And that is the problem we have. But again, you know, I understand that the case he cited to in Iowa, there is also one that I cited to, which very recently in the state of Minnesota, which was a judge who cut off all pleas on the day before trial. And the court said that was okay, because it was, again, within this context of trying to make the jury system more efficient, and then he had that discretion to do that. I think if you look at it in the context of there is no constitutional right to plead guilty, and in the context of this, where the court is really trying to make the system more efficient and giving defense and Commonwealth more of a chance to get their case together before the day of trial, that it makes sense, and it's a reasonable limitation to limit it to the day before trial. Unless the court has any further questions.
All right, thank you.
Thank you.